Hi, this is Kelly McLendon, Managing Director of CompliancePro Solutions, and this is a continuation of our series on hot topics, HIPAA, and information blocking. Today we're going to talk a little bit about PHI and EHI, which unfortunately are going to serve to confuse many people. Under HIPAA, you're probably familiar with the term PHI, Protected Health Information. There are 18 identifiers that are needed in some kind of information to make them become PHI or protected health information. One important note is that PHI only applies to HIPAA covered entities and business associates. Otherwise, HIPAA does not apply. Now, that's a lot of providers, payers, like insurance companies and businesses that work with them. It's in the hundreds of thousands of different businesses and providers, I'm sure, that use HIPAA and PHI, but it does only apply to them, not outside of that world. So these are the 18 identifiers that are considered PHI, and notice number 18 is also any other unique identifying number or characteristic or code. So it's quite a wide set of different identifiers within data we call classes that would be considered protected health information. HIPAA also has a concept called the designated records set. It's a group of records maintained by or for a covered entity that's either medical records, billing records, but it's about individuals, and it's maintained by or for a healthcare provider. It also can be enrollment, payment, claims adjudication, case management, or medical management record systems maintained by a health plan, or is used in whole or part by a covered entity to make decisions about individuals. For the purposes of this paragraph, the term record means any item, collection, or grouping of information that includes protected health information and is maintained, collected, or used or disseminated by a covered entity. That means paper records, electronic records. As long as they're in a record system or are kept as a record, they will be a part of the record set, and certain of those record sets at a covered entity or a health plan would be part of a designated record set. If the information is used to make a decision about a patient or is one of those other record sets that are named, those are designated record sets. And to those designated record sets, many of the HIPAA rights, such as the patient's rights to be notified of breach or to have access to copies, those are all attached to the designated record sets. So HIPAA has had this designated record set definition for quite some time, and it can be confusing, but it's now also going to be used within the definition of electronic health information, which is a part of the 21st Century Cures Act under the Office of the National Coordinator of Healthcare IT, or ONCS, Information Blocking Final Rules. In this rule, they focus the scope of the EHI to mean Electronic Protected Health Information, or EPHI. So we learned in the previous slide what PHI was, but now we're taking that definition of PHI and saying anytime it's electronic and would be included in a designated record set, then it is now going to be called also EHI. The difference between PHI and EHI is that if a patient had, let's say, a smartphone that had an application on it that went out and grabbed a medical record from a physician's office through, let's say, a portal using APIs, which are those application programmer interfaces, or whether it was another way that they received the information, if that information goes back to the cell phone application, that cell phone application will not most of the time be covered by HIPAA. It will in fact be outside of HIPAA. So what they've done now is said if you have PHI or group of records that contain PHI in electronic form and you move it outside of the HIPAA system, now we're going to call that EHI. That's electronic health information. Can't be protected health information or PHI because those smartphone applications and many, many other applications are not covered by HIPAA. The law doesn't cover them or protect them. So you can't say that the information they got on the patient is PHI, so we say it's EHI. They also, ONC, the Office Coordinator of Healthcare IT, identified that on October 22, EHI, for the purposes of information blocking, is limited to the data elements represented in the US CDI standard, which I'm going to talk about in another snippet of video. But in other words, we're going to show what the US CDI standard is. Those are data classes, different classes of information. That's going to be limited until October of 2022, when then any information in the patient's designated record set could be accessed. So for now, the information blocking rules are going to apply only to the US CDI data set, which again, we will talk about in another presentation. Any patient information coming from a certified EHR, electronic health record, that's been certified by the government portal is considered EHI. You can have information in the portal also be from non-certified sources, such as other systems besides your EHR system. So that would be EHI as well if it came out through the patient portal. EHI in the 21st Century Cures Act information blocking rules and the designated record set. Under HIPAA, the patient's rights are applied to PHI within the designated record set. Under the 21st Century Cures Act, information blocking and CMS interoperability rules, they apply to EHI within a designated record set. And again, initially, if it's a part of USD CDI, the 21st Century Cures Act information blocking and interoperability rules recognize and use the concept of designated record sets, but they deal directly with and address EHI, not PHI. That's a fine distinction. It can be very confusing. So HIPAA's talking about PHI. 21st Century Cures Act, information blocking, is talking about EHI. Some rules apply under HIPAA that do not apply to other organizations that are not healthcare entities under the information blocking rules, but they both have to have the concept of designated record sets. You have to be able to enumerate which data classes will go into your designated record set, which is, again, the record sets where you make decisions about patients or create medical records or billing records. I know it's confusing, but sometimes you're going to hear information called EHI, sometimes you'll hear it called PHI. If those terms are correctly used, that will indicate to you whether the organization is trying to manage HIPAA or whether they're trying to manage the information blocking rules, which again are very intertwined. So remember, EHI is EPHI in a designated record set of whether the entity is covered by HIPAA, either a covered entity or a business associate. And the designated record set's denoted by the organization that manages the health information. So if you have an application on your cell phone that's managing your medical record information, that application's company gets to decide what the designated record set of which are the record set that you can get copies from. They'll decide what record set that they're going to use. It's always going to be confusing to speak about HIPAA's terms and the 21st Century Cures Act terms. Therefore, really, we need to be fluent in both. I want to thank you again for your attendance today. And if you have questions, don't hesitate to contact me.